Without further ado, I will give the floor to Mr. Spijkers. Otto Spijker is Assistant Professor of International and European Law at Leiden University College. And before joining Leiden, Mr. Spijkers was Professor of International Law at Wuhan Universities in China. And before that, he worked at the Utrecht Center for Water, Oceans and Sustainability Law, and his doctoral thesis was relating to the UN, the evolution of global values and international law, and it was presented at the Grotius Center for International Legal Studies at Leiden University. Dus Mr. Spijkers has all credentials, and please, you have 15, 20 minutes maximum, and thereafter we will have enough time for a session of question and answer. Thank you.
Yes, indeed. I was told we have a slightly stricter chair now compared to before the lunch. So I will limit myself to 15, 20 minutes max. I do have, oh yeah, okay. So I have to operate them myself, right? Yeah, okay. So my lecture is about, it's very local. It's actually about litigation in the Netherlands, my home country. But of course, because we have such an open jurisdiction, it's actually a lot about international law. Hey, that's me. Can I have the slides back? I mean, I like to look at myself, but maybe the slides are more interesting. So you start the timer now, right? So yes, in the litigation I will refer to, I will discuss with you a lot of references made to the European Convention on Human Rights, and then in particular Article 2 on the right to life, and Article 5, which basically is the legal basis for the right to a healthy environment in one or other shape or form. So I will talk a lot about public interest litigation, so the Urgenda case and everything that is inspired by it and followed it. They are all public interest litigation cases. So they are all initiated by a foundation established under Dutch civil law, purporting to act in the general interest, whose aim is to influence public or corporate policy rather than get compensation for itself or for its constituency. So using the courts to influence public or corporate policy in this way is called public interest litigation. And this has increased in popularity in recent times, in part because of the success of the Urgenda case. So let me freshen up your memory quickly before I turn to what's next. So climate litigation is a subcategory of public interest litigation. And the best known example in the Netherlands is still the Urgenda case. So Urgenda is a foundation established under Dutch civil law to protect the current and future generations of the Netherlands from dangerous climate change. And Urgenda began its case against the Netherlands already in 2012, so a very long time ago. So we first had a ruling by the district court in 2015, then the appeals court in 2018, and then the case ended at the Supreme Court level with a ruling in December of 2019. And briefly put, the Supreme Court of the Netherlands then held that the Netherlands government must ensure that greenhouse gas emission levels from the Netherlands are significantly reduced. Otherwise, the duty of care, inter alia informed by these two provisions of the people of the Netherlands, will be breached. There's a lot to say about the Urgenda case, but I want to focus on one aspect of it before moving on to the next. And that's the references to the interest of future generations, because there's a lot of misunderstanding about this. So the appeals court is the most pronounced. The appeals court ruling is the most pronounced on this issue. And the court said the following, and I do want to quote. So the state of the Netherlands argued that Urgenda cannot act on behalf of the future generations of Dutch nationals. In view of the appeals court, the state does not really have an interest in that ground of appeal because Urgenda's claim is already admissible insofar as Urgenda acts on behalf of the interest of the current generation of Dutch nationals. After all, and now I read from the slide, it is without a doubt plausible that the current generation of Dutch nationals, in particular but not limited to the younger individuals in this group, will have to deal with the adverse effects of climate change in their lifetime if global emissions of greenhouse gas are not adequately reduced. So basically the court is saying, no, this is not a case about future generations' interests, it's a case about present generations' interests. So, and the Urgenda case does explicitly not deal with future generations' interests. So what happened after Urgenda? There's three cases that I'd like to focus on. First is the Shell case, then there's a case against the Royal Netherlands Airlines, KLM, and then there's a case against ING, a major bank, also based in the Netherlands. And if time permits, I will also say a few words about the Bonaire case. So all these cases that I will mention from now on, they're all still pending, so there's no final ruling yet. So let me begin with the Shell case. In 2018 already, Milieudefensie, that's Friends of the Earth Netherlands branch, they began a case against this giant global oil company that everybody knows, Shell, which was at that time still headquartered in my hometown, the city of The Hague in the Netherlands. And then in May of 2021, the district court delivered its judgment, basically agreeing with Milieudefensie that Shell was doing too little to reduce greenhouse gas emissions and prevent serious climate change, damage. So I guess the Shell was not very pleased with this ruling, so they immediately relocated their headquarters to London to avoid further climate litigation. But of course, these proceedings, they will continue. So they're now on appeal. Actually, we already have an appeals ruling, but first I want to say something about the district court ruling. Because on Milieudefensie's claim that it was representing the interest of future generations, the district court had an interesting thing to say. It said, the interests of current and future generations of Dutch residents are suitable for bundling in a class action like this one, even though in the Netherlands there are differences in time, extent, and intensity to which the inhabitants will be affected by climate change caused by CO2 emissions. So again, the court has no problem bundling the interest of present and future generations and really did not see a difference there. So again, this is not a case about future generations' interests. So on appeal, and I think this is interesting to mention, two other foundations joined in the proceedings, and they are Clintel, a bunch of climate deniers, so they deny the climate science. And then there's another foundation, the Stichting Milieu en Mens, Environment and Man, or Humankind. And they wanted to present the interests of all Dutch citizens who are more interested in being provided with energy security rather than a healthy environment. So I quote from the press statement of Stichting Mens en Milieu. Milieudefensie initiated the proceedings in the general interest, but the M&M Foundation, a bit awkward abbreviation of course, argues that there is much more to the public interest than just the climate interest, and that these other interests have not been taken into account by the court. We want to introduce these aspects into this case by intervening. So it echoes a bit what our chair said before the break, that not all foundations are the good guys. There's also bad guys that may engage in climate litigation. So on the 12th of November of last year, the Hague Court of Appeal ruled in the appeal between Milieudefensie and Shell, basically ruling that Shell has an obligation to Dutch citizens to limit its CO2 emissions. And this obligation, and that's quite revolutionary, stems from the human right to a healthy environment, which includes, according to the court, protection against dangerous climate change. So while it is primarily the government's responsibility to ensure the protection of human rights, of course, we all know this, these rights, according to the court, also indirectly impact the due diligence that companies like Shell must observe. So according to the appeals court, from international human rights law also derive obligations for corporations like Shell. So that's the good part of the ruling, but the bad part is that the Court of Appeal did basically dismiss all of Milieudefensie's claims. And the reason being that the Court of Appeal could not establish that due diligence requires Shell to reduce its greenhouse gas emissions by a very specific percentage, 45%. And that is what the claimants had asked for. So they lost on appeal, and now the case is before the Supreme Court, so the ruling is still pending. And now I want to look at another example, that's the Fossielvrij lawsuit. So Fossielvrij, again, another foundation established under Dutch law. They started a lawsuit against Royal Netherlands Airlines, de Koninklijke Luchtvaartmaatschappij, for misleading sustainability claims, or what's more commonly called greenwashing. And the question was whether KLM misled its consumers when this airline advertises its green activities. And I just wanted to show you some examples of this greenwashing. So here, no, where is it? Yeah, so here you see, there's a shadow of an airplane there. So you see an airplane flying over these green fields, as if there's no environmental problem. And the most interesting, I think, and the most particular is this advertisement, be a hero, fly CO2 zero. Basically suggesting that the more you fly, the better it is for the climate. Of course, I flew from Amsterdam to Rome on a KLM airplane, so I'm making my contribution. I always wonder which brilliant mind comes up with these slogans, be a hero, fly CO2 zero. This is, of course, not an ad from KLM. So this is from the website of the claimants, Fossielvrij Nederland, basically making the point there's no such thing as sustainable flying. There is a final ruling, or well, no, there's a ruling on the merits, I should say, but only from the Amsterdam District Court in this case. And the court ruled that the number of advertising statements made by KLM in the past were indeed misleading and therefore unlawful. And this Be a Hero campaign, that was actually stopped because of this climate litigation. And on November the 6th, so last week, 21 major airlines committed themselves to change their practices regarding environmental claims that were considered misleading by the Consumer Protection Cooperation Network. So you see the impact of climate litigation very clearly. So all these 21 airlines, including KLM, they have committed themselves to stop claiming that CO2 emissions of a specific flight can be neutralized, offset, or directly reduced by simply paying a sum of money, a financial contribution to climate protection projects like reforestation. That's a fraud, and the airlines have now acknowledged this. And of course, the climate litigation has played a big role in that acknowledgement. Yeah, I do want to say something about Fossielvrij's claim that they also represent future generations, because I thought this would be an interesting common theme. So if you look at the Articles of Association of Fossielvrij, you see that their purpose, it's in Dutch, so I will translate it for you. You can understand, but most people will not be able to understand. So the foundation's aims of the foundation is to aim for the benefit of current and future generations to promote, protect, support, and achieve social, environmental, and economic justice, and health at the local, regional, and national level, and to remove social legitimacy of coal, oil, and gas companies, the so-called fossil companies, and airlines are often included in that category. So on the 7th of June 2023, the Amsterdam court already accepted that Fossielvrij could legitimately claim to represent both current and future generations. And there's an interesting paragraph justifying that conclusion. So I again quote the originals in Dutch. I will provide English translation. So fossil-free represents all natural persons living in the Netherlands at the time of the summons, and those who are born and come to live in the Netherlands after the date of the summons. So those are the future generations who are affected by climate change. These natural individuals cannot be individualized, especially now that fossil-free includes all future residents of the Netherlands as part of this group. The action of fossil-free is essentially a general interest action, and in the context of a general interest action, it's not feasible for the interest organization to name all its supporters, let alone to make it clear that it concerns sufficient persons with a view to its representativeness. It's a bit of an understatement because it's not only hard to do so, it's actually impossible to name all your future supporters because they are not yet in existence. But the court did accept that fossil-free could also represent their interest. Then I want to talk about another case. How much time do I have? Okay, I can talk about two more cases then. So let me turn to my third example of post-Urgenda climate litigation in the Netherlands. So this is a case, again, initiated by Milieudefensie, so Friends of the Earth Netherlands. They also initiated the Shell case. And this time they demand of ING, a big bank based in the Netherlands, to halve its total emissions and stop collaborating with polluting companies that jeopardize our future. So these large companies include companies in the industrial and aviation sectors, but also oil and gas companies that continue to expand their projects financed by ING. So ING is currently reportedly investing around 26 billion euros in companies that are still developing new oil and gas fields all over the world. And it also has dozens of deals running with oil and gas companies that will continue to develop new fields even after 2040. So now you might wonder, does a financial institution like a bank, the ING bank, does it actually emit greenhouse gas? It's just people behind computers, right? Well, no, of course not. They don't emit much greenhouse gases themselves. So it primarily concerns financed emissions. So that refers to where the situation in which a financial institution's money is invested, for example, loans to companies building gas-fired power plants are offered. And that accounts for basically all of ING's emissions. 99.9% of all emissions are produced in this way. So this case has only just begun, so there's no ruling yet. But the argumentation is roughly the same as that was used in the Urgenda case, and it's the same lawyer who is behind it. But what I find interesting is already now ING is starting to sort of protect itself legally. So now if you go to the website of ING, they basically already acknowledge, so although we finance a lot of sustainable activities, we still finance more things that aren't green. But we're always looking to take our next step to drive further progress to a low carbon future. So they're basically acknowledging, making public to all of us that most of the finances are not green, but in the future, we're working on it. I think I have 1 minute left. So, this Bonaire case, it was initiated after the deadline for submitting my slides. So I don't have a slide, but this is a slide about Bonaire. So it's a Caribbean island that belongs to the Kingdom of the Netherlands. So just imagine a beautiful tropical island, okay? That's the Bonaire. So the Caribbean island of Bonaire is a municipality of the Netherlands, a gemeente, like the gemeente Den Haag. But it does not enjoy the same climate change protection as the Europe-based municipalities. Billions of Netherlands dollars, or euros rather, are spent protecting the Dutch coast from rising sea levels, but there's no comparable plan to protect Bonaire from rising sea levels, floods, heats, storms, tornadoes, hurricanes, and so on, that the residents might suffer in the future and are actually already suffering. So the plaintiffs, it's Greenpeace actually this time, but also a few individuals living in Bonaire, They argue that the Dutch government is committing an unlawful act to them by failing to take adequate climate action with respect to Bonaire. And they again base their claim on the alleged breach of the right to life and right to a healthy environment as protected under the European Convention on Human Rights. But they also allege that the Netherlands is discriminating them by not offering protection to them and offering protection to people in the European part of the country. So yeah. This will be one of the first climate litigation in the Netherlands that is initiated after the advisory opinion of the International Court of Justice that we heard so much about before the break. So that may be very interesting in what way the plaintiffs and later also the court makes use of that advisory opinion. So again, no ruling yet. This is really a case that has only just been initiated. So thank you very much for your kind attention.
Thank you very much for this overview of climate litigation in the Netherlands, and thank you for staying within the 21 minutes.